Anytime you're ready.
Thank you, Your Honor, and may it please the Court. My name is Homero Lopez Jr., and I represent Mr. Nkenglefac. I'd like to reserve 5 minutes for rebuttal. The Board made the following 4 errors in their decision. First, finding that the IJ properly relied on extrinsic evidence and making her adverse credibility finding. Second, finding that Mr. Nkenglefac waived his argument regarding extrinsic evidence by not moving to admit that evidence at the immigration judge level. Third, upholding the IJ's adverse credibility finding. And fourth, finding that the IJ did not abuse her discretion when she unfairly left the evidentiary record open for the government, but not do the same for Mr. Nkenglefac. I will address each issue in order. Starting with the extrinsic evidence argument, which gets to a due process issue. In rendering her decision, the immigration judge improperly relied on extrinsic evidence not admitted into the evidentiary record. There should be no dispute as to whether this evidence was ever part of the evidentiary record. The notes from the Border Patrol interview and the notes from the credible fear interview were not part of that record. Contrary to the government's argument in reply, it is clear that the documents were never admitted into the evidentiary record. The transcripts and written decision are clear that the IJ, throughout her meticulous and detailed discussion, listing and labeling of exhibits, did not admit these documents into evidence. Further, all 3 panelists at the board agree, even though they arrive at different conclusions, that these documents were never part of the evidentiary record. The board's first error arises in simultaneously holding that the documents are not part of the evidentiary record and that the IJ properly relied on those documents in making her adverse credibility decision. Mr. Nkenglefac respectfully submits that the board is simply wrong, and that its explanation for affirming the IJ's decision is illogical, contrary to both case law and common sense. This court, in a string of cases between...
So we're not looking for substantial evidence. This is a sort of threshold question, procedural, almost constitutional, right?
Yes, sir.
The IJ referred to something ex parte.
Correct, Your Honor. This is a constitutional due process issue on a legal ground, and the court should be reviewing it on a de novo standard.
And you made that argument to the BIA?
Yes, Your Honor. We make the
How do you
argument...
understand their response? Even though the 3 of them all agreed it wasn't in the record, they said what?
They said that the respondent that Mr. Nkenglefac waived his right to make that argument on appeal because he did not move to admit those documents into the record at the immigration judge level. And I'll be getting to that point as well, but I can move that.
No, continue.
This court has, from Faris through Singh, has a long string of cases and precedent establishing that you cannot review things outside the record, that these documents are generally reliable, you can review them and rely on them, but they must be in the evidentiary record. The person must be given an opportunity to respond to them. If there are any...
Those are different points, in the record versus opportunity to respond, because we have law that says if the discrepancy is obvious, no one has to say, well, why don't you talk about that obvious discrepancy?
Correct, Your Honor.
You're saying that case law is all embedded in items that are in the record.
Yes, Your Honor, because we can't know that a discrepancy is obvious without knowing that those documents exist, or without knowing that those documents are being relied upon for making the decision and being used as evidence if those documents have never been served or provided to the respondent, have never been admitted into the record and into the evidentiary record and discussed during the hearings.
I suppose, and I want to let you keep going to all 4 points, but I suppose one answer would be, but these items are unique and distinct because they're his own statements, and he must have known what he'd said.
They are unique and distinct, Your Honor. As the CFI itself makes clear, it is not a verbatim transcript. These are documents, and as the board itself has made clear in matter of JCHF, they made clear that the documents that the judge must assess the accuracy and reliability of those documents when they're going to rely on those documents. Even though they are, Mr. Nkenglefac is not making the argument that those documents cannot be relied upon, that those documents generally are not reliable documents, and as government-produced documents do not carry some inherent level of reliability. The argument that that Mr. Nkenglefac is making is that those documents must be admitted, that he must be given due process. He must have notice.
You don't dispute the NTA refers to them.
The NTA does not refer to the documents themselves, no, Your Honor. We do
It mentions there was a border interview and a credible fear interview. No.
The NTA does not. The NTA, as this court,
Contained in the NTA?
they are not contained in the NTA. As the Supreme Court, through Pereira and
Well, they're not contained in it, but I thought the NTA itself just mentions they happened.
No, Your Honor.
Okay.
The NTA is listed, and the judge did, in her very meticulous approach, and evidencing that meticulous approach, she questioned both Mr. Nkenglefac at the very first hearing and his counsel at the third hearing regarding the NTA. The NTA, the Supreme Court, through both Pereira and Ms. Chavez, this court has been having a lot of discussion about that as well. Rodriguez-Garland, towards the end of last year, was decided by this court where they also addressed what is an NTA, and there's been a big discussion about what is an NTA.
Okay, I see. The NTA, though, was scanned in evidence,
The
correct?
NTA, yes. And what,
No, there's no one, all three judges on the BIA agreed with you.
Correct.
The credible fear interview never did get in.
correct.
Okay, so that's your first argument.
That's our first
I don't mean to cut you off, but
No,
time's
that,
quick.
I appreciate that, Your Honor. Yes, that is our first argument. That document was never, those additional documents were never admitted into the evidentiary record. There's no evidence that they were ever served on either the respondent or his counsel.
Still on your first argument?
Yes.
Okay.
And there's no evidence that he was cross-examined. There's nothing that shows that they presented this evidence to him to be able to respond to it. Allowing such a procedure is fundamentally unfair and contrary to case law, common sense, and undermines our system of justice. Moving on to the waiver argument, Your Honor, which is the part where the board argues that Mr. Nkenglefac waived his argument on appeal because he did not move for those documents to be admitted into the evidentiary record. That framework is illogical, contrary to case law, and does not make any sense. It's impossible for Mr. Nkenglefac to achieve. Under the board's proposed framework, Mr. Nkenglefac should have first speculated during the hearing that the IJ might choose to rely on some document that had not been discussed or admitted into the evidentiary record. Second, guess which document that might be. Third, guess that the IJ would find inconsistencies between that document, his testimony, and the other evidence actually in the evidentiary record. Fourth, presume that the IJ would then rely on those hypothetical inconsistencies to find him not credible. Fifth, preemptively move that the IJ admit the document into evidence. And sixth, finally, preemptively rebut these as yet unstated and purely hypothetical findings of inconsistencies. The board's articulation of Mr. Nkenglefac's obligations before the IJ is unworkable for several reasons. First, the board cannot reasonably expect an applicant to foresee that the IJ intends to rely on extrinsic evidence and then preemptively correct that error. Requiring the applicant to preemptively correct the IJ's error to preserve an argument for appeal is particularly illogical, since that correction would make that argument no longer be an error on appeal. He would have already moved to admit the evidence into the record, therefore it wouldn't be extrinsic evidence anymore. It moots the issue and it puts the burden of presenting typically impeachment evidence
I read
on
the
the
whole
respondent.
record obviously for this hearing, but correct me if I'm wrong. He never said, as I told the border people, as I told the asylum officer.
Correct, Your Honor.
No one ever referred to these.
At no point.
And yet they are pretty central documents.
They are, it's astounding to us that no one ever referenced it. It's astounding to us that the government never referenced it, given that they are the ones who have possession of those documents. Again, there is no evidence in the record anywhere that shows that these documents were served on Mr. Nkenglefac or his counsel. At no point do they have a certificate of service. The only document that was ever admitted into evidence was the Exhibit 1, which is the NTA. The judge specifically speaks to him and asks him about page 2, is that your signature on the certificate of service of page 2? She then further asks his counsel at the third hearing whether he has a copy of it as well, and he admits to service of the NTA. The NTA is a term of art. It's statutorily defined.
But you don't get counsel at the border or credible fear here, so it's almost ineffective for a lawyer not to ask for those transcripts to make sure there isn't something in there. That has nothing to do with the issue before us, but.
I would disagree with Your Honor. There's nothing in the evidence that shows that that attorney did not review those documents. Nothing tells us that he didn't have a copy of them. What the board is asking is that he should have moved to submit those documents. As a duty as an attorney, it would make sense to review those documents and prepare your client for cross-examination.
And alert the government and the court to, this is a problem, my client might lack credibility because of this.
That's assuming that you find inconsistencies
Okay,
within
go
it.
to the third point for me, just because time's running.
Understood, Your Honor. Thank you. The third point being the adverse credibility finding. On the adverse credibility finding, even if we consider the extrinsic evidence, there is no inconsistency beyond that which is to be expected when somebody repeatedly recounts a lengthy, detailed history of their story. The wording might change, but the story remains the same.
Well, this is his first time in any court to ever try to explain it. Are you saying there is no inconsistency, or you want to explain it now?
I'm saying there is no inconsistency.
Okay, and the 2 points he identified were what?
Yes.
She.
There-
Sorry.
Sorry, no, go ahead.
No, she said there too, and they are what?
They focused on two specific, the board focuses on two of the IJ's inconsistency findings. The first one being that he uses the term several when it relates to his arrests. And she says that at the Border Patrol, he only addressed one. And then during testimony, he only speaks of two. To hold somebody to a dictionary definition of the term several, which, sure, under the dictionary means more than two, but is colloquially used as meaning more than one. And if we look at it through a totality of the circumstances lens,
Several means more than two in the dictionary?
dictionarily, yes. Exactly our point, Your Honor. He repeatedly...
Give me an example of somebody using the word several to mean two or one.
Mr. Nkenglefac said, I was arrested on
Besides-
several times.
I don't know, maybe we have different intuitions, but to me, several means more than two.
I would say I've been to Houston several times. That could be more, to me, that's more than one. You've been there more than one time. And as a colloquial usage,
Can you give me an example of,
I ate several cookies.
I mean, I know you can say it here. My point is, does
Whether-
anybody actually use that terminology?
Not necessarily an example that everyone would have heard, no. But what I can get at...
Right? He didn't mention that the father had been killed.
Correct. If I may finish just on the several point real quick, Your Honor, he specifically describes those two arrests repeatedly. So the totality of the circumstance demonstrates that he is speaking of those two incidents only when he's saying, even though he's saying several. He's also a Cameroonian English speaker, not an American English speaker, and the judge, as well as the board, should have taken account of that aspect. In Britain, for example, they say holiday to mean vacation. In the US, we use it to denote a particular day of celebration. It's the same word, having different meaning based off the cultural interpretation of it.
Just to confirm, the facts are it's two, right, not one?
Yes, Your Honor. The facts...
The question is basically, does several contradict two?
Correct. Regarding his father's death, yes, he did not mention that during the CFI, and he only mentioned it during the testimony. However, that ignores the process itself and how the process works, as well as the setting in which it was happening. So, the question at issue was, what made you leave Cameroon? The question that he was asked by the asylum officer who is directing the interview is, what made you leave Cameroon? A very open-ended, broad question, which he responds to in an overarching answer that generally addresses his membership in the SCNC. The asylum officer then asks him, when did you decide to leave Cameroon? He continues answering and giving details regarding the persecution. She then follows it up 2 more times with the when question, making it very clear that she's moving away. She's checked her box as to whether his rationale is there, she's moved on, and she's moving on to the next step of the process, which is to determine the when did you leave, and making sure that potentially a 1-year deadline or return or something else might be in effect. And so the system, the way it is set up to go from the Border Patrol interview, where it is a quick interrogation of determining whether someone who appears to be inadmissible should be summarily dismissed from the country or should be allowed to proceed to the credible fear interview. And then the credible fear interview, which is intended to elicit information about a preliminary prima facie case. Can this person make a prima facie case of eligibility so that we can send them to a final evidentiary hearing? And in an evidentiary hearing, which is the first time he gets to affirmatively tell his case. And that's...
The brothers killed, the house is burnt down. Those are because of his membership. Was the death of the father related to his membership or because the father wanted to keep his rifle?
I don't think they necessarily have to be one or the other, Your Honor, but they were in connection to the same thing. They were taking his rifle from him as they shot him, but the initial part of that was that they came to him in order to search the house because of the SCNC membership. I see my time has run out, but if there are other questions, I am happy to respond.
You say time for rebuttal?
Yes, I did. Thank you, Your Honor.
Thank you. Ms. Perry?
May it please the Court, Rosanne M on behalf of the Attorney General. Substantial evidence supports the agency's denial of petitioner's claim of asylum, withholding removal, and cat protection. First, the record does not compel the conclusion that petitioner is credible. There's a significant discrepancy between his border interview and his asylum declaration regarding how many times he had been arrested. At the border interview, he stated that
I'm going to interrupt you with the threshold question. But you cite cases for us. It is a lenient standard, substantial evidence, pages 11 and 16 of your brief. But do any of those cases allow us to say substantial evidence referring to evidence that wasn't ever in the record?
well, the evidence is in the
No,
record.
I'm asking, do any of the cases that you cited to support just a substantial evidence review, did any of them turn on evidence not in the record? I'm asking a question about the cases.
I don't recall the,
It would seem unlikely.
I'm sorry?
It would seem unlikely.
Yeah.
Okay, so here, does your argument rise or fall on the factual proposition that these interviews were actually in the record at the asylum hearing?
Yes, they do.
But didn't all three members of the BIA agree at least as to that they weren't in it?
Yes, the two that.
No, all three, even the dissent, I mean, the majority
Yes,
of
they did. They did.
So the government's saying that the BIA was wrong, clearly erred.
I honestly don't know where the two board members got it from, where they said that it wasn't in the record or that.
But your argument depends on us finding that all three members of the BIA were wrong factually.
No, I mean, for the most part, the two members that got it right, that he was not eligible for asylum, but they did say that the interviews were not in the record, or they said that he waived.
IJ did have an exhibit list. You agree?
Yes.
It was on the exhibit list.
Yes.
You agree with that?
But the asylum IJ referral packet contains the interviews, and that was submitted or filed by the IJ in June, I think, of 2018. Yes, so back to the border interview and the asylum declaration. He said he had been arrested once and detained for a week, but in the asylum declaration, he said on several occasions. It's clear that he said that he was arrested during a strike in 2017. But then he says that, and that it was during the strike. Then he says that he was arrested on several occasions. This is a clear discrepancy.
But the asylum officer had both interviews, correct?
I'm sorry,
The asylum officer, we know that person did have both interviews. The asylum officer at the credible here was listening to him and had the border statement, had both.
I suppose
Okay, but that person then said, I find him to be credible.
Right, but I don't know that he had the border interview statement.
The asylum officer wouldn't have had the border interview statement?
Well, he was at the credible fear interview, but I'm not certain that he would have the border interview statement.
If he did, it would seem highly illogical that he would have said this individual's credible, and then the IJ say, no, not credible, based on the same two interviews, right?
Right.
Okay.
There was also discrepancy with regard to his father's death. At the credible fear interview, he doesn't mention his father being killed, but then in his testimony and his asylum declaration, he says he's killed. It's telling that his siblings' affidavits don't mention his father's death, while they do mention his brother's death.
The IJ was very active in questioning, and it's a long hearing. And then Ms. Chu for the government was very active. Do you agree that neither of them ever asked him any question suggesting that he'd spoken inconsistently before?
No, it's not clear that they did do that.
Can you point to anywhere in that whole day's hearing where any of them even said he was evasive, or any time he even said, I don't know? What would you point to in the hearing itself that either the IJ or Ms. Chu for the government ever even intimated this man spoke inconsistently? Can you point to anything in that day's hearing?
No, I cannot. I cannot. But the IJ doesn't need to point out his inconsistencies to find that he's not credible.
Okay, and your best case for that? It does seem a little like gotcha. You're going to say to the individual, you've incriminated yourself. I don't believe you because of your own words, but never draw attention to those words? I thought that inconsistency would have to be really glaring and obvious.
Well, a cite to that?
Any case.
It's Singh v. Garland, and it says the IJ is not required to give an applicant the opportunity to explain inconsistencies before reaching an adverse credibility determination.
And do you remember what the inconsistency there was? It doesn't matter.
Yeah, I can't remember. So moving on to his withholding claim.
What claim?
His withholding of removal claim.
Okay.
He didn't meet his lower burden for asylum, so he can't meet his burden for withholding. And with regard to his CAT claim, the adverse credibility determination suffices as a basis to deny his CAT claim as well. With regard to his reliance of the border and credible fair interviews, he was aware of his statements. He confirmed them at the end of the interview, and he didn't say that there was anything discrepant or wrong with his statements. The asylum IJ referral packet was included in the record, which contained the credible fair interview and the border interview. With regard to the agency's exclusion of petitioner's evidence, the agency reasonably found that the evidence was untimely filed and should be excluded. The documents were dated January 2017 to August 2018, so he had an opportunity to get them to the court before his October 22nd hearing. Petitioner does not show how the judge's consideration of the evidence would change anything. If there are no further questions, the government would ask that the court would deny the petition for review.
Thank you, counsel. Your client was removed, right?
He has been physically removed from the country, yes, Your Honor. To address specifically the Singh case that the government cites, it is correct. Singh does say that the judges can rely on this information. These are documents that are reliable. Again, that is not Mr. Nkenglefac's argument here, that they cannot be relied on. The issue in Singh, he was confronted with the CFI. In Singh, he was asked about those inconsistencies. He was given an opportunity to respond to them.
But we do have case law, very recent case law, that says you don't even have to give an opportunity if the discrepancy is obvious.
Correct. If the discrepancy is obvious, clear, something that they should very much be aware of, yes. But in this case, the discrepancies are not. Using
Well, they're not until it's not even in the record.
Correct.
You had a fourth argument, that
Yes.
it's sort of unequal treatment.
Yes,
The
sir.
government gets to do the forensics, but yours are stricken after 2 days.
Correct. And
Law
even
that
so-
says that an IJ can't treat people differently? Gives the government a chance but doesn't give you? I mean, it seems unfair on the record, but what would be the law to allow us to reverse?
On the disparate treatment, Your Honor?
Yeah, that was your fourth point, right?
Yes, the fourth point is that the government cannot leave it open for one side to be able to submit evidentiary evidence, but not to the other side. That argument relies on the fact, in this situation, judges are given a lot of discretion when it comes to that issue. To setting deadlines, they can be harsh deadlines. That is understandable, and that is given a lot of discretion. They do, however, have the discretion to also extend those deadlines. And in extending those deadlines, you have to rely on the circumstances of the case and the circumstances of that situation. In this situation, the circumstances surrounding Mr. Nkenglefac's case is he's a detained asylum seeker in central Louisiana. His family, who is collecting the documents from him, are in Cameroon, which is a war-torn country going through civil strife, and they're trying to get the documents to him into the U.S., where his attorney can then file them. His attorney files them within a day after he receives them. It's 3 days after the filing deadline that the judge gave. And then she leaves it open and takes some documentation from within that very submission to hand over to the government to run this forensic, which is going to be potentially negatively towards him. That is an unfair standard, right? The standard for admission of evidence into immigration court is that it be probative and fundamentally fair. And so if she was going to be addressing it in that way with the government, she should have at least given weight. She completely excludes the
Board
findings.
counsel. As I read the record, the IJ was pretty upset at prior counsel because the prior counsel didn't even show up on time.
Yes, Your Honor.
But, okay.
I was not. I was not
But I
counsel.
will say something, you're pro bono?
Yes, Your Honor.
You made an excellent argument, both sides have. Did you file a reply brief, or you chose not to?
We chose not to, Your Honor. It was as we started to present it, COVID hit, and it just ended up creating a situation for us where we couldn't based off of our situation, unfortunately.
So if a federal district court gave one side a continuance and did behave this way to the other side, I take your point that sounds like an abuse of discretion. What's your best case for the proposition that we apply those same standards here in this sort of admittedly more deferential standard where we're reviewing Article 2 in the immigration context?
That would be U.S. reincarnation Galvez, where one person.
I'm sorry, can you say that
Yeah,
again?
you better say that again.
Excuse me?
Just go ahead and read the citation in for the record.
964 F. 2nd 402.
And why do you cite that case?
So, apologies. In that case, the government addresses that, or the court addressed the defendant after he was convicted illegally for illegal reentry. He did not read Spanish well or speak English at all. He was agreeing to voluntary departure. There was no deportation, and so he did not knowingly waive his rights in that hearing. They were using the information that had been collected from somebody who was not properly prepared to submit that evidence, and they were using that evidence in order to then convict him for illegal reentry.
Look, if that's reviewing a federal district court.
Yes, that's reviewing a
Because
federal.
what I'm asking is, this notion of one side got extra time, the other side didn't, that's an arguable abuse of judicial discretion by a federal district court. Do we apply those same principles to the IJ process? It may be obvious that we do. I'm just asking the question.
Yes, Your Honor, I don't have a citation for you at this moment, unfortunately.
6 seconds.
The CBP interview regarding the strike is not a measurement of time. And so he did say the strike during 2017. Both arrests happened during 2017 when he then explains them.
And I'm going to go past the red light. Do you know whether the asylum officer had the border?
There's nothing in the record to show that they did, Your Honor. Typically they do because they're referred.
Find your client credible.
The asylum officer did find our client credible. Yes, Your Honor.
Okay, thank you, counsel.
Thank you.
Case is submitted. Should we go to the last case? Thank you. Okay, go right through. We are going to go straight through. Final case for the day is 21-505.